section and slowing down traffic, or interfering with traffic, I should say. In this case, the plat that came before you in July, they were, because of the shallow lot depth, the site is constrained. And so the way that they were proposing to make it work at that time was that they were requesting 2 variances and also a waiver. That plat was denied by the Planning and Zoning Commission. Since that time, they've redesigned the plat, and so now it meets the county's subdivision regulations. And the way they were able to do that was after the July meeting, they applied to the Board of Zoning Adjustment for a variance to allow a shallower front yard setback from these proposed dwellings and that internal street. So rather than being 25 feet from that internal street right-of-way, private street right-of-way, I'll call it, or easement, now I believe it's 20 feet that it needs to be a minimum of 20 feet. And that's allowed the subdivision to be redesigned. And so what you have before you here is a similar plat to what you saw before, but its main deficiencies have been corrected.
Any questions for staff? Hearing none, I ask the applicant to come forward. Evening, Mr. Goss. Do you swear to tell the truth, the whole truth, and nothing but the truth in these proceedings or in the pains and penalties of perjury?
I do.
Please state your name and address for the record.
Brad Goss, 120 South Central, Suite 700, Clayton, Missouri, 63105.
Go ahead.
Okay, well, I'll just work with that on the what's on the screen. The actual front yard setback that we got the adjustment to is 21 feet. It's not 20, not that it particularly matters. So we had a 4-foot adjustment. As Robert said, what we did after the plat denial was we went back and redesigned the project. As you recall, we were wanting a waiver for the tree preservation. We redesigned the street so that we would be able to preserve the trees that we were required to preserve under the ordinance. So we're compliant. We had we talked about changing the way the right-of-way was treated, and that was one of the variances we requested, and that was not something the commission was comfortable with. And so the right-of-way is right-of-way. We're not asking for any kind of variance or change with respect to that. And it works because we did go to the Board of Adjustment and get a variance for that front yard setback, because the problem with this property, because it is so narrow, it wasn't buildable unless you got 4 feet of relief. So the plat that you see in front of you is absolutely 100% fully compliant with every subdivision regulation of the city of St. Charles County. So there is no variance being requested. This is a compliant plat. And I'm happy to answer any questions that you may have.
Any questions for the applicant?
Brad, where was it? I'm trying to recall on the tree preservation from the last one. What was it?
It's over to the right. Is that common ground is where all the trees are being preserved?
Yeah.
What we did was we changed the curvature of that road and changed the slope a little bit. So we're putting this, I think the way the engineer is solving is we're putting a very small wall to make it work. And so that we don't have to grade as much. That was the problem. And so, and what we were doing is providing compensatory trees on the other side. So, the message I heard was, don't have any variances. So I went back to the engineer and said, your mission, don't have any variances. So that's what we were able to accomplish.
Mm-hmm.
And I remember that a lot of the residents that came out were just opposed to it no matter what, and we kind of asked them what they wanted. I don't see any of them here tonight necessarily, so have you guys been able to talk to them about this? And okay.
No, but the thing that they were concerned about was the trees along that back line, and we are not disturbing those. Yeah. So that seemed to be the thing they really cared about.
Ms. Spamer, Mr. McDonald, do you have any questions?
No questions.
Okay, thank you.
No questions.
Okay, anyone else? Okay, thank you.
Thank you.
We will now open the public hearing for application number PRE 20-13, villas at Lake St. Louis. Anyone wishing to speak? No. You solemnly swear or affirm that you'll tell the truth, the whole truth, and nothing but the truth in these proceedings under the pains and penalties of perjury.
Yes, I do.
Please state your name and address for the record.
Thank you very much, Mr. Chairman, members of the Planning and Zoning Commission. My name is Arnie C. A.C. Dienoff, public advocate and county resident. I'm sorry, what else did you say? Was there one other thing? Did you say?
Your address.
Mailing address
P.O.
is
Box, yep.
P.O. Box 1535, O'Fallon, Missouri, 63366. As you all know, I'm very opposed to this piece of property. The number one opposition is the density. First of all, let me just back up and make it a matter of public record. I was wondering if you could ask staff about notification to adjoining property owners, the adjoining neighborhoods, and the adjoining homeowner associations. Was there proper notification? Was there proper publication of this zoning matter, the zoning hearing, before the Planning and Zoning Commission? This is a brand-new issue, so were they properly notified? Was there notification to the people within 400 feet or the proximity?
We'll ask them that question.
Okay. So that's my first thing. I'd like to make a matter of public record. The second thing is the density issue. As you all know, our county codified ordinances say 4 homes per 1 acre of property. In this case, there's 5 homes for 1.1 acres, and the density issue. In my opinion, this project should be scaled down to 4 homes. The second issue is turning radius for fire rescue vehicles, turning radius for school buses from the Wentzville School District, turning radius for refuge trucks and recycling trucks. Is that cul-de-sac large enough to accommodate those large commercial vehicles? A couple other things that I have concerns about are the landscaping of the property. If you remember, the adjoining neighbors that abut to this had some property value issues about this. It would diminish or decrease their property values being so close to the property line. I would like to see some increase of landscaping, increasing of trees, planting of additional trees with the preservation. Hopefully they're going to meet the county code for preservation of the tree ordinance, and create some type of berm to mitigate the effect on the adjoining property owners, especially with their property values. And the final issue that I'd like to address is surface water protection, retention, detention area. Upon review of the plans, I don't see anywhere where it talks about retention, detention of this property. As you all know, when you take up the saturation rate, the land rate with driveways, with homes, you take away the saturation absorption rate of the ground, and that water has to go somewhere. Those people downhill, right next to this property, right up against this property's property line, McBride Homes, I believe, is creating a new detention retention area, pond for this area because of water concerns and water runoff. But that hasn't been addressed in this plan whatsoever, and I feel that our code isn't adequately addressed in that process. Now, it is true that they did go to the Board of Zoning Zoning Adjustment. I wish I would have been on top of my game and been in that meeting, because I would have opposed giving them the 4 feet, their variance that they requested. However, I guess it's a good trade-off for the tree preservation that section 410.145 of the codified ordinances be maintained. For those reasons, I'm opposed to this project. The neighbors, I don't believe, have been properly notified, or they would have been here. They were adamantly opposed at the last meeting. They weren't notified or brought up to speed with the changes in the developments, and I think it's kind of unfair to those residents that didn't have ample opportunity to appear before you and testify. For those reasons, I'm opposed to this project. Thank you, Mr. Chairman.
Thank you, sir. Anyone else wishing to speak regarding application number PRE 20-13? Anyone else? Seeing no one, we will close the public hearing. Ask the applicant to come back. Anyone have any questions for the applicant? Additional questions? Seeing none, hearing none. Thank you, sir.
I can respond to his comments if you'd
Okay,
like me to.
if you want.
First of all, this is not a rezoning, as you know. It's a plat approval. So all of that conversation was irrelevant. As for the density, it is compliant with the requirements of the zoning district that we're in. So that's also non-responsive. The radii of the cul-de-sac is compliant with the county requirements. And the landscaping, because we are preserving all of the trees that we're required to preserve, there is no additional landscaping that is required. And then, of course, we are preserving beyond that the landscaping behind us. And the surface water and detention, we will obviously comply with all of the St. Charles County requirements, but the water doesn't run, took my plant down. The water doesn't run back toward the neighbors. The water runs toward the street, toward Dwello. So the concerns that they had about water running onto them absolutely can't happen because it'd have to run uphill. So I think that answers the questions that Mr. Dinoff raised.
Any questions?
So the street that's back there is actually sloping, I guess, from back to front somewhat.
Well, the whole ground slopes toward Dwello.
Right, but I mean, typically roads are crowned.
Right. So when they do the final detention designs and the calculations, they go through that finally when they do the improvement plans. But he's already done the preliminary calcs, and it's compliant.
Okay, thank you, sir.
Thank you.
Now we'll bring this back to the commission for consideration. Any questions for staff?
So what about notification? What's the rule on preliminary plats?
Notification, we properly notified everyone as required by ordinance. For plats, it's adjacent property owners, so we notify adjacent property owners, and I would note that that did include notification of the homeowner association for the subdivision to the west, because they own the detention basin that backs up to most of this. Not just detention basin, they own the common ground that backs up to most of this property. So we did notify them. We also notified the city of Lake St. Louis and also 2 other municipalities as well. Let's see, Darden Prairie. In fact, I got a call from the city manager for Darden Prairie. The reason we notify other jurisdictions is because in our code it says that if you're within a certain distance, a municipality can protest. And so this area happens to be close to several municipalities. And the city manager indicated that they didn't have a problem with the application, or the plat, I should say.
Thank you.
Any other questions for staff? Hearing none, the chair will entertain a motion to approve application PRE 20-13. Is there a motion? Mr. Hollander made the motion. Is there a second?
Second.
Mr. Kuhn made the second. Mr. Fromm, how do you vote?
Yes.
Mr. McDonald, how do you vote?
Yes.
Mr. Hollander? Yes. Ms. Bamer, how do you vote?
Yes.
Okay, Mr. Clary?
Yes.
Mr. Kuhn?
Yes.
And I vote yes. Application passes.
Thank you.
Okay, now let me get back to the agenda. The next item on our agenda is preliminary plat for the re-subdivision of Hoffman Hills Lot 30, located at 30 Hoffman Hills Drive. The application number is PRE 20-22. The owner-developer is Christopher C. Vaughn and Lisa M. Vaughn. The engineer surveyor is Landmark Surveying Company. The zoning is A, Agricultural District. Proposed lots is 2. Parcel size is 10.82 acres. Location is on the south side of Hoffman Hills Drive, approximately 165 feet south of Hopewell Road, 1/2 mile from the city of O'Fallon, located in Council District 2. Staff.
Okay, this application is essentially to divide one lot into 2. Hoffman Hills subdivision was platted in 2007 and includes 6 lots. Of those 6 lots, 5 of them are around 5 acres, and then 1 of them is a little over 10 acres.
3. They're all 3 acres.
3 acres, okay. And then then 1 of them is about 10 acres. And so in this application, the proposal is a re-subdivision of Lot 3 into two lots, A and B. In this case, they're proposing not to front Lot 3A on a street, and that's for a couple of reasons. One is that this 10-plus acre parcel has enough room in the back conceptually to build a house in the back, but I understand from the applicant that they propose to, once this lot is created, to de-subdivide this parcel and to instead take access from Hopewell Road to the north. So it would be out of the subdivision, and it would take access from the driveway to Hopewell Road to the north. And that's the essence of what's before you here. So instead of building a street to a parcel that is proposed to be de-subdivided, the proposal is instead to place an easement from Hoffman Hills Drive back to Lot 3A. And that easement would provide access to that lot in the meanwhile until it gets until they have access from Hopewell Road to the north through the driveway.
Any questions for staff? Hearing none, applicant has already come forward. Please will raise your right hand.
Sorry.
Do you solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth in these proceedings under the pains and penalties of perjury?
Yes.
Please state your name and address for the record.
My name is Chris Vaughn, and I live at 30 Hoffman Hills Drive, Winsfield, Missouri, 63385.
Okay, go ahead, Chris.
I do have this thumb drive.
Okay.
I don't know if I need it or not, but as evidence, but I'll go ahead and proceed.
Is it what's on the screen over here?
No, there's several slides. One is, prior we moved in, I went through the indentures, and there were a lot of things that, they just took cookie cutter plat from big neighborhoods. And I saw sewer, $400 a year. Well, they're not paying that. So I said, you need to take that out, this out. And when we purchased the land, it was sold, it was as is, 2 acres or 2 lots or 1 lot. He was getting split it or buy it. So before purchasing, I said, I want the right to still split that. So I sent an email back and forth. That was the correspondence, which I sent some of that. They had, before he said he could prove it, he would have to go to the homeowners and let them all know. So he went to the homeowners. They approved it. One of the neighbors who's complaining about it also signed it and approved it. And this was in 2012 when I purchased it. We've lived there, built the house 2013. We moved in, and now we're moving out. And I don't know how much detail you need on all this, but okay. And I thought, okay, I'll let them know I'm dividing the land, even though I thought it was already approved. They didn't like it. They said it's going to add more traffic, whatever. So I found a way not to add traffic by getting to the back through Hopewell Road. And there's plenty of room that no one will see it. It butts up to our lot and the neighborhood of the homeowners and one other homeowners association. And that's a ditch. And I really would like to do this. Okay. I think visually seeing is better because there was an opposition, and I guess I want to respond to the opposition. Oh, I do it here. I'm sorry. Okay.
And just one second here. I need to pull out the keyboard.
Oh,
So,
well, I'll just need the mouse.
mouse clicker.
Okay, thank you. I have these in order, so I'm just. Okay, this is the initiation before I purchased the land in 2012. This is where he said it was necessary. He'll be seeking homeowner approval. And after the homeowner approval, which I've already provided through the portal, the meeting, minutes of the meeting and such that approved it before we purchased the lot. And I can't read this very well here, so I don't know when I'm opening each time. Okay, this is the contract. And he put it in the contract, too, that the approval, well, this is the wrong one. Oh, no. Anyway, there was, with this contract, unless I passed it, there's an addendum added to this, and it's not on this page, so I don't have it here. But I do have it anyway, it included the ability to split the lot in that. And this, he's already showed you this, but I'll show you where the house sits. Our house sits here. There's plenty of room, and you'll see there's plenty of room to build a lot. And I'm going to show you what the other lots look like in comparison to the complaint. I guess I should walk through this gentleman, his first complaint. I guess I was explaining why he's complaining about the, I guess I have the opposition here too. Let me just show you that. I thought I could talk, I can open both, right? And talk back and forth. Well, maybe. So he's gone on to say a lot of things, the Hertz. And he's step one, he's indentures of our subdivision we all brought in to say cannot be split. You might have read this because it is on in the portal. I don't know if everybody's read this or not. So I just wanted to give my response to it. And prior to purchasing is what I went through just now. And then his second complaint was we were the first people in the subdivision. We bought in a small lot. There's 5 small lots, 1 big lot. So knowing the potential up to have, but they were selling our lot, lot 3, as 1 or 2, so it would have been 7 possibly. And those 2 lots still would have been bigger than the smaller lots. Anyway, he's talking about people dividing ½ acre to 1 acre. I don't know. I'm dividing it in half, a 5-acre lot, so I'm not sure what he went on to say there. No house will be built near the Hertz. In other words, out of his sight, line of sight, and I'll show you that in another drawing. All the neighbors had a right to buy this land before me, so I don't know why they're complaining. Let's see, go on to the next one. More importantly, the 10 acres on the 3 lot. Lot 3 is mostly unusable, and I disagree with that totally. It's beautiful flat land. I heard it was a cow pasture before. It's grown trees and stuff since. It's the best part of the lot. It just sits way in the back, and I was not going to build my house there. So I sit up high. We all sit up high. It sits down low near the other houses. Behind it, there's a Fort Knox neighborhood, and it would align with the same level as them. And the Edwards that's across the creek, it would align with their house as well. So, and let's see, the new lot's a beautiful flat. Yeah, we have planned to build or sell a house. I'll probably sell it because, just tell you, we're going through divorce, we need the money and such, so we're just need to split that money. Number 5, he's gone on to say, as stated above, we do not know where the new driveway will be and such. And I think Robert's explained that and such, and we have access from Hopewell Road. It will not impede any of the neighbors or activity. And number 6, he says, we also do not want more traffic. Well,
So
we're going to
Chris,
get to the back.
Can you tell me where that road's going to come in off Hopewell?
Sure.
I mean,
I
it's
can
through
go to the other
is it through
drawing.
somebody's lot? Is that through somebody's lot, Robert?
No, it's the Edwards property, and we've already
Which
made
is-
an agreement and swapped the land.
Can
So
you guys bring that up?
Yeah.
And what,
how do I get on this?
she'll do it. Ellie will do it.
Ellie's,
I clicked on the background, and apparently this came up. So
they can bring up Ellie's laptop.
oh, that was it. Thank you. Okay, so I need to get back to that. Let's see.
Chris,
Yeah, I'm looking.
Ellie's doing it. If you can just let her do
Oh,
it.
I'm sorry. She doesn't know which one to open, though.
Yeah, she does.
Oh, she does?
Yeah, she's going to open up to something that we have in front of us.
There you go.
Okay, thank you. I'm sorry. I had this
So how
similar.
is he going through 3394 or something?
Yeah, see 3394, I have a drawing that shows where that we'll have access. See that little, right
Is there
there,
an
that little
easement?
section there? It will go all the way, butt up. So move your mouse to the keep moving down right there.
Is
The other
that that
corner, go to
person's
the other
lot?
corner.
Is that
We will,
the-
right there, right where arrow is, we'll come right through there. And I can show you the drawing on that. I think Mark and Robert seen that.
Is there an easement?
No, it's a quick deed claim.
So the person that's on 3394 is going to give you a quick claim to that section?
We're
to get the
swapping
whole-
land, and I can
I
show you the
gotcha.
drawing.
Okay.
Okay, sorry.
I was just curious how you're getting to that road, and if you're not going to just,
No, we've already
Okay.
got arrangement, everything's,
all right,
yeah.
all right,
Yeah, and I can show you a drawing of that.
that's fine.
Do you want me to show you the drawing?
No, as long as the neighbor's fine with it. I wasn't clear on when Robert was talking about it, so that's all.
Okay, okay. Yeah, he's going to get .09 extra land for the swap, so it's
I got you.
5.09.
You're giving
So
him-
I'm giving 5 even, make it 5 even, and he's
Okay.
getting it. He was happy for that. It's also a buffer for him and where his house sits. It's that little, it'll be a little rectangle there.
Mm-hmm.
And as, I'm glad you have this drawing up. See how very slight 40 is, and 50 and 60, all the trees in the back?
Mm-hmm.
It's really unusual, and we're coming way in. No one's going to see this. No one's going to, and that's the flat area right there. It's a beautiful flat area. There's not, no, it's a prime part of the lot. We just never took advantage of it. We also, if you've seen the indentures, you probably can't go through everybody's indentures. We're allowed to have horses. We're allowed to have barns. Lot 3 had a lot of exceptions, and it's in the indentures, the bylaws. So, yeah.
Okay, thank you.
I had a question. You said that you had pre-sale of the property and agreement in which you were allowed to split the property. Can you please show that to us?
I put it through the portal. So that was the minutes of the meeting that, and I talked to the gentleman yesterday. His name is Tim Dugan. He sold us the property. And he said that all the neighbors agreed, and that's the only way they can make a change. He thought it was a change in the indentures and doesn't know why they're fighting. The minutes of meeting were sent to all the neighbors. They had this in 2012. And when I try to act on it, I'm getting feedback.
So did you have this layout, 2012, you're showing us today? Of
This
it
access to the back, I did not.
split? No, I mean of it being split.
No, I did not know how I was going to split it.
They just gave him the right to split.
Sir, can I ask you, why the discrepancy between what they told you in 2012 to the 2019 meeting, which is stated in here that was held, and,
Well,
obviously, that sounds like two different
If
stories.
this is a problem, I'm going to get a lawyer. It's a rogue board. It's seriously.
So what now?
A rogue board.
Rogue board, okay.
They're not following the rules. They got second house built has a front-facing garage. The indentures say no front-facing garage. They got a flagpole says no things hanging out, which I don't care. I really don't care about all of it. Someone moved in. They still claiming they have 2,500 square feet. Indentures say it must be 3,000 square feet unless you have 1,000 in the basement. It's 25 living area. So they're all, and there's a chicken coop up front, which I really don't care about all that, as they do, but as I do, I thought I was doing the right things. And I don't, like I said, it's just how it is.
How many of the same people are on this board now that were actually living there in 2012, 2013 when you built your home?
Only lot 1 has transferred ownership.
Okay, so these are like 5 different people than when.
I'm the 5th. They're the 4th. So
okay,
yes.
When this
And
originally came.
they rotate themselves. I try to get on the board. Why would they be afraid of me? I said, you need liability insurance. They'd have, we better go do that. I mean, I was on the board in a homeowner association and Philstone Farms. I kind of know the layout and everything. That's why I came in when I read the indentures. You guys don't need this. I want to be able to put solar panels. The future, this doesn't allow it. So those were the things I was adding. It was all for everybody. Yeah.
I'm looking through the packet of information and I don't see any addendums to contracts or anything showing where you can split the property. Is there something that staff can share to show us that?
I can show you. It was in the portal. I sent it on.
At this point, we don't have, what we need is recorded indentures or covenants.
And I can, let me explain that then. They forced him out. As soon as the 5th lot was sold, they wanted him out, the gentleman that sold the land. So I don't think he got to act on that. And I don't think he knew how to act on that, I'll tell you the truth.
Okay. Just for clarification, normally with most plats, the Planning and Zoning Commission and the county as well doesn't take into consideration covenants or restrictions because it's considered to be an agreement between two private parties that the county's not party of, except we are involved in covenants and restrictions in some ways having to do with like street maintenance, things like that. Except with re-subdivision, the Planning and Zoning Commission can take into account, specifically the Planning and Zoning Commission, the governing body or director of the Division of Planning and Zoning may take into consideration the limitations on the re-subdivision which are imposed in duly authorized and binding subdivision covenants, indentures, or restrictions, if any. In the preceding paragraph, it says that as part of this consideration that certified copies of recorded subdivision covenants, indentures, or restrictions, if any, should be provided. Now, what we have at this point is a Word document that provides the covenants and restrictions, but we don't have anything that's been recorded showing that this is like the official copy. What I'm trying to say is you can take into consideration, because it's a re-subdivision, the covenants and restrictions, but at this point, we don't have already certified or even recorded copies of those.
So what you're saying is that the indentures from the homeowners association has never been recorded?
I don't know that. We just don't have any that's been submitted as part of this
If they
application.
haven't been recorded, then they have no standing, no effect.
Yeah, I spoke to the gentleman that sold it, that was on the that made the changes and got with all the homeowners. I talked to him yesterday, and he said he'd never filed it. He said he didn't know. He thought that was the rule. And, regardless, he was selling it as 2 lots, and it's 10 acres, yeah.
Can he file it now? Can he file it now? Or not? I'm not a lawyer, so. What about it? Where's our lawyer?
I have the minutes of the meeting, and I provided that then.
Yeah.
No, because it's all new property owners.
They did prove it,
Yeah, we understand that, but
yeah.
from does it affect our decision-making though on this? I mean, we can still give them the authority to divide a lot.
You can take that into consideration according to this section of the code.
But we can not take it into consideration too.
Because it's never been
Right.
filed, it's not
Right.
effective.
Yeah,
Exactly.
right.
Yeah, you can also, not take it into consideration
Yeah,
as well.
because
It's not a legal document.
If I was gonna go buy this lot,
Yeah,
and we do the
It's not filed.
title search,
Yeah.
it's not gonna show up.
yeah. So you're gonna have a problem trying to sell a lot later when someone's gonna look for recorded deeds and stuff like that on this.
Well, the deeds will be there.
Or not the
They
deeds,
won't-
but the contract to do what he wants to do, or whoever you're gonna sell it to.
Well, but it wouldn't apply.
It wouldn't apply. I've already put a petition to remove it out of the homeowners association. That's next month. I talked to the gentleman about doing it simultaneously. That made a lot more sense, but
See, if they haven't ever filed the document,
Right.
okay? So then you do the title search, it's not gonna show up.
Okay.
So those covenants that they have, those indentures,
Not gonna make a difference.
don't make any difference.
Yeah, that's
Because
true.
if they don't show up
Yeah.
in a title search, if they're not of record, then it doesn't apply to the land.
Doesn't matter. Yeah, you
Doesn't
can do what
matter.
they want. Okay.
I'm not sure what you're saying, but
It's just legal.
If they've never filed them with the county, okay? The original homeowners associations, their covenant restrictions, indentures, people use a lot of different terms. Then they have to be filed to attach to the land. So that's never been done, and then those don't apply.
okay.
So were they irrelevant?
Yeah.
Pretty much.
If they've never filed them. Because when you do a title search, it's gonna show up. So if it's never been filed, then it's just You could call it a contract, and it's a civil dispute between the parties.
Can we, Robert, I have a question for you. So you say on here, it doesn't meet technical preliminary plat. So if it did, does the county have an issue with it? I guess is one of the questions. And the other question is, without this having a street access and it being a landlocked property, can we approve it anyway? Because it doesn't meet it. I mean, you know, we know that he has exchanged it, but we don't have anything that shows that.
I have it up here now.
I mean, is it recorded? Is it shown on a recorded document?
Yeah, we did a quick deed claim. We swapped land.
And it's recorded?
And I got a drawing of it
And
right
it's
now.
recorded?
It's recorded. There it is. And I wanted to show you their lots, how narrow they were, and that 5-acre lot's pretty broad there. There's 4 acres out there with 1 acre on the front. I worked hard for this.
We just don't want you to, we don't want to do something that's going to cause you problems on the road too. It's not just about doing it well, we're supposed to. It's about making sure you're not going to get.
Okay.
Yeah, that's my concern too. I mean, you're dividing it in half 10 acres, but I think there's some other issues here that could cause you problems.
What?
Well, I think that we're not sure, but I would say that you're putting this access on that driveway right there. I don't know what that's going to mean in terms of approval. Hopewell Road is windy and steep
Yeah, I
and
drove
narrow
it,
through
yeah.
there. And, I mean, do you have approval from the county on that?
There are other requirements. I'll let Robert speak.
I can answer some of your questions. One is the plat before you, is still lacking some technical requirements such that are easily resolved and fixable. For instance, adding the proper signature block, adding the contours at 5 foot, 2 foot, or 1 foot intervals to the plat. There's a number of other things that can be addressed that aren't difficult to do so. Your question about can you even approve a lot that doesn't have frontage on a roadway? The answer is yes, but it's a special request to you for your consideration. It's not technically a variance, it's a waiver, and it says that the Planning and Zoning Commission, if for topographic reasons or if there's an equal or better solution, can consider approving a plat with a lot that does not front on a public or private street, but instead on an access easement. So occasionally you have done so. For instance, I'm thinking of, I'm trying to remember the name of the plat. It was off Fimi Osage Road. There was one lot within that subdivision that fronted on an access easement. But that's an example.
And that won't be an access easement. It will be part of it'll be the land swap part of the deal, right? It's not an easement?
Well, it'll be a driveway, I guess. I don't know what the details are for the area to the north. The other thing I would mention is this gentleman has submitted a request to de-subdivide the property, and that request will go to the county council. But really, before you can de-subdivide, you've got to have a lot that's created. You can't really de-subdivide land that's not yet, or parcel that doesn't yet exist.
Okay.
So we advise that the proper step is do this part first, create the parcel, and then apply to the county council to de-subdivide that. Those are the 2 steps involved.
And that's next month.
Yeah, and we do have that application in to de-subdivide, but we don't have a lot that's existing yet to de-subdivide.
Now, shouldn't a preliminary plat include, how's this land swap, the ground for, let's just call it an acre for conversation, this acre of ground for the driveway to Hopewell, how's that going to get connected to this parcel? Legally, not physically, but how will that become part of Lot 3A?
Well, the requirement that lots front on a street, either public or private street, that requirement is in the subdivision code.
Yeah.
It's not within the zoning. So if it's not in a subdivision, you have farm parcels that are 100 acres and they're not on any street, and they just have access easements. And those are unplatted parcels that have never been
that's true.
platted.
Yep.
And that's the situation that this parcels would be in if it's de-subdivided. It's just going to be kind of floating, a parcel that's floating out there, and they're going to have a driveway access via an easement or crossing their own land to get down to the nearest roadway.
Okay.
Now, to have the driveway on Hopewell, do they need any approval from the county
Yes.
to place it there?
Yeah, they would, if it's a new driveway access, they would need a special use permit from the highway department.
And is that something that we can assume?
Well, it's a typical request. They receive those requests, I don't know, daily is the right word, lots of them. But one of the considerations is site distance. They always look at site distance up and down the roadway, for example. They have to look at things like stormwater culverts going under the driveway and other considerations like that. But I honestly haven't been involved in any discussions about site distance, for instance, up and down Hopewell Road and whether there's trees in the way or anything like that.
I drove it, and I looked at the site distance, and there's a driveway there close to it. And there's several driveways along that road, and the turns and hills and such. That's a long strip. There would be an area that I can put in there. I'm pretty sure of that.
Okay. Anything else you want to?
I don't know if you wanted to keep responding to his other notes that he put on there.
Okay.
I mean, if necessary, the opposition. I think we might have answered them all. Oh, it's several tabs. Let's see. Opposition. Okay. Number 7. Oh, let's see. The Vaughns will split the land behind existing home between another lot, butts up to Hopewell Road. Landlocked. So they're talking about landlocked, which we've already discussed. And we do not want to lose our privacy and security. I mean, you saw the area, it's below my land. It's going to be butted up, and that's long strip. That area, that long strip there. Don't know if I have it on this drawing. Yeah, I guess. This is the only strip of land, and see how narrow it is? I mean, it butts up to one person at the very bottom of the hill there. And going to his next opposition, let's see. We do not want to lose our privacy either, okay, we did that one. He's talking about the culvert agriculture, water and such, if he's concerned with that. And something was added on my lot, which is a 100-foot, 3-foot pipe. I have put a lot of dirt up mounds, so it's my driveway. And I can show you that drawing. It's really, is not affected at all. That is, it's a dry water, it just flows right between his land and my land. We both own parts of this ditch. So that whole 5 acre, this 4 acres out here, roughly, 1 here, 4 here, it's not near that at all. In fact, I won't even be near the creek, except that I have to cross over the creek. There's a creek here.
Okay. In the letter from Hertz,
Yes.
okay, they make a statement, that, if I can find it again, that we all agreed to written recorded indentures for Hoffman Hill subdivision that were to be good for 30 years since their recordation in 2007. Have you done any type of search from the county records to determine whether they've been filed?
No, I have not.
Okay.
I know he didn't file the changes, but I don't know about their initial.
Do you have, anyone have a copy of the agreed to change
Copy of the changes I've asked?
that you requested?
Yeah, I put them on a portal, and I have them right here. Minutes of the meeting from which one of the, and I showed you the email where he had said he's going to go to the homeowners to get all approval. He did his due diligence. He's a real nice guy and made sure he stayed in for the long haul.
Can I see a copy of that?
This is what I put in. And those minutes of the meeting, I know he sent it to all of them. I mean, like I said, he was very articulate.
So is there something then signed by the homeowners association? That's my biggest concern, saying that they recognize that this split, or there's something in a contract where this split was agreed upon before you bought the land, it was a part of the land deal. That's my big concern, is there doesn't seem to be anything signed and recognized by the homeowners association or the land deal.
Well, the board signed it at the time when I purchased it. And they reached out to all the neighbors. There was 4 others at the time. And there was only 1 house built at that time. So the other 3 were under construction or going to be under construction.
And so there's a document that they all signed agreeing to it.
Yeah, they went and sought approval from the neighborhood, and one of the homeowners signed it as part of the board. There were Bunko Group members for life, 3 of them. And the other one, Tim Dugan said he would reach out to him.
Okay, so you have that document, and it's part of your presentation.
Yes, it's in the portal too.
Yeah, Tracy, I'm reading it right now.
Okay, thank you.
Can I get to the portal through here? Oh, there it is, yeah. Oh, that's the indenture. Oh, that might, there it is. Yeah, it's in the portal. Thank you.
I need binoculars.
Well, it was little things like they had sewer that you had to pay $400 a year. I said, we don't have sewer. So I told them you should take that out. And the little things. Like I said, I went through this fine tooth and comb, the indentures.
So Tim Dugan signed it,
And I think there's another gentleman that signed it too.
and he's one of the trustees. Well,
Yeah, Tim and,
you could get anybody.
okay, I got approval from Alan. Alan, here's the.
Yeah,
They met at Ruby Tuesdays.
yeah, they met at Ruby Tuesday.
Alan sent the email. I thought he signed it too. He was the other board member.
Okay. Okay, so this is a trustee meeting, which would be a board meeting.
Right.
The board approved these changes, but without seeing all the indentures, whether it requires a vote of all the members of the association. Yeah.
And if they haven't filed those.
Well, this was approved as a variance for Lot 3 and a permanent change to be incorporated in the indentures at a later date. That's what it says. So,
Yeah, when Al sent that, the other 2 members weren't on the land, they're friends. He would go reach out to the other 2 and send the approval. That's what they had to inform the homeowners. And that was that initial email that Tim said he was not going to do anything until he talked to all the homeowners.
but did the homeowners association ever have a meeting required by their indentures?
I couldn't tell you how they did the meeting.
Where this was voted on and approved in accordance with what's in the indentures. The fact that the trustees, unless the trustees have the right to change the indentures, which I would doubt, but without seeing that document, to me, this.
It was a very informal vote. They just reached out to everybody, and they all saw it, and they agreed to it, and that's how they submitted it.
Yes, I'm a
We get
president.
it, yeah.
I'm president of a homeowners association right now, and the way ours read, to change, well, we have to have a yearly meeting, which is coming up in November, and if there's a change, then it has to pass by a certain number of property owners. But
Not just a trustee signing it.
yeah, but if the 3 trustees, or directors as we call them, we can't unilaterally make a change to the indentures.
Do we know if the homeowners, has ever been filed, the indentures?
There's a statement here that says that they were filed in 2007. I don't, that's why I asked if there's ever,
Oh, I don't know.
if you've ever done a title search, come here to well, down the hill to the county to see if there's anything of record.
Okay. Well, the person that they're talking about on the board is the wife of the husband that sent the email and approved it, so it's just,
Yeah. So, I mean, we can continue with this. Sure. And take into consideration,
I would not have bought the land.
yeah,
There's a lot of loose ends.
yeah. I know, I mean, we can continue, we could table, can we table a preliminary plat?
You can, yes.
You can vote on, approve it too.
They also vote to not approve it too, so we don't want to do that too. We want to get it right.
Kevin like that.
You could,
Yeah. We can continue this at the request of 3 commissioners. We can continue the discussion to a vote.
What is your time frame on what you're going to do with the property?
My house is on the market for sale. I've already come down over 100,000. I mean, we're losing money. This land is the only thing that's going to keep us afloat. We just lost our son. I'm going through divorce. I mean, I can give you all the sad stories. It's true.
Yeah, I feel your
Yeah.
pain, but I want it to be right for you too. It's
Yeah.
just about, I mean, it could be something that happens, you're not going to like it too.
Yeah.
It could get approved, it could get denied.
Right.
Then you have to go to county council and try to get it over. Well, does it even know? There's no,
Well, I was up front in how I purchased it, everything, all the questions I asked, everything I did.
Yeah.
I just,
I do have one question here. On their number 3, they say that they allowed you to build a large barn because it was a 10-acre site, and that none of the other places on there, none of the lots were allowed to do that. I mean,
It's-
was
it's
that
part-
presented to them that it was gonna be, that barn was gonna be on a 5-acre, potentially a 5-acre site? Or was it presented that it was gonna be part of a 10-acre site?
it meets the 5 acres, 2,400 square feet, and that's the max for the 5 acres. And it's going to 5.7, so it's over 5 acres. And I know that too. And I made it 40.
No, I'm
yeah.
not questioning whether it's compliant with it.
Okay.
What I'm saying is, when it was presented, it seems like they're taking umbrage with the fact that you are now trying to divide it when you presented it as a 10-acre site to build a large barn. Am I reading this incorrectly?
I don't know, you mean his opposition to it?
Yes.
Well, on the premise that he was notified and the minutes of the meeting were sent to them that I would possibly split it in the future, and it has to be 5 acres, what I understand, in the St. Charles County. So I'm not sure what he was referring to there. But it's not oversized, doesn't exceed.
That's fine, I guess
Okay.
it's one of those he said, she said.
And Lot 3, it's in the subdivision, or in the indentures, that Lot 3 can build the barn, have horses, 1 horse per acre and such, and other things. And it said I could only have 2 animals, so I said, you got to change. Anyway, this is some of the extra things I was asking for before I purchased the land.
I'd like to see some proof that this homeowners association even exists, or if they're really legally, can make decisions or not, I don't understand this.
Yeah, I don't know.
I really
did. 2007, but we just don't have any proof of that, right?
Correct. In the letter from
Hertz.
Hertz, they make a reference that it was recorded in 2007, but we don't know if that was in fact accomplished.
So let's just assume that it's correct, and we vote on this. What's the outcome if we vote for or against? Is it any different whether there's indentures or not that are filed?
Yeah.
Yeah.
Here's the way I look
Yeah,
at
it doesn't matter.
Yeah, it really doesn't matter.
Here's the way I look at it, is that he's just asking to subdivide it a 10-acre lot with access that's not even going through the subdivision, which is most of their objections. It seems to me the thing to do would be to, if I were gonna vote, would be to vote for it, but subject to approval of the access by the county department of the driveway. It seems to me that solves all the problems.
Robert?
That's certainly possible to do, and there's, I think, 11 points in your memo about things that need to be addressed in order to meet all the technical requirements. I would say they're easily addressable. Things like provide the appropriate signature block, indicate the date of the survey, provide a legal description, which they provided, it's just not on the plat.
There's a lot in here.
Depict the topography, indicate the average lot size for the re-subdivision, et cetera.
Yeah, he provided me, the surveyor provided me an incomplete, but half updated. It's on the view right there.
Okay. I mean, so to follow along your lines, I suppose you could, one option might be to approve it subject to certain conditions.
Right, okay.
That's
fine, that's all it is.
Yeah. Okay. Anything else?
I don't think so.
Thank you, sir.
Yeah, thank you. Keyboard.
We will now open the public hearing for application number PR.
Just pull it out.
Pull it out?
Pull it out.
Okay, I didn't know that ejected or.
There you go. Public hearing for application number PRE 20-22. Anyone wishing to speak regarding this application, please come forward. You solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth in these proceedings under the pains and penalties of perjury.
Yes, I do.
Please state your name and address for the record.
Thank you very much, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dienoff, County Public Advocate and resident. Mailing address, P.O. Box 1535, O'Fallon. First of all, I'd like to request that the commission table, a motion to table is in definite order here, till we get some definite answers and needed documents. I want to make sure that our county and our 430,000 county residents don't face any legal consequences or precedences set in this case. Matter for the record, was notification made to both the city of O'Fallon and the city of Lake St. Louis? Were all the other 5 lot owners legally notified by mail as required by county code and state law? As you all know, the code does give you some leniency under provisions of section 410.480D of the county code. And I want to recite, the Planning and Zoning Commission may waive the requirement that any proposed lots not take access from a county roadway where there is a topographic hardship, or if any equal or better alternative can be provided that is not in agreement with this ordinance. So my question to you as commissioners is, where's the hardship? The hardship has not been demonstrated by the owner or the applicant. State law talks about definition of a hardship in Chapter 67, the revised state statutes, which regards Board of Adjustments in terms of municipalities and County Board of Zoning Appeals. A hardship needs to be proven. And in my opinion, I see problems here. I see many lacking documents and a possible legal lawsuit by one of the property owners against the County of St. Charles. In my opinion, I think that the tabling is in order. We're putting the cart before the horse, just to make it a matter of public record. There are numerous areas that the subdivision regulations, Chapter 410 of our county codified code, have not been met. We apply this standard and ask for these documents up front from all other applicants. Number one, we're lacking the identification of natural water courses and vegetated buffer requirements. The applicant needs to provide exact limits and dimensions of natural water course vegetated buffers as preserved on the record subdivision plat. That's pretty major. 2 is to provide a soil evaluation for septic approval. That's pretty major. That's not just a technical deficiency. Number 3, provide the appropriate signature block. Yeah, that's a technical issue. Number 4, indicate the date of the survey. That's a technical issue. 5, provide a legal description. That's a major issue here, because we want to make sure that adjoining property owners' rights aren't trampled on. Number 6, depict the topographic of the tract with contour intervals of 1 to 5 feet on the USGS datum. 7 is to indicate the average lot size for the subdivision. That's a major requirement, not a technical one. Number 8, indicate all property owners within 100 feet of the perimeter of the plat. It's pretty major in my opinion. Number 10, as Lot 3A would not front on an internal subdivision street, but instead take access from Hopewell Road, submit a written request for a waiver from the requirements of Section 410.280A.2 of the subdivision regulations. That's a major requirement that he hasn't gone over that hurdle. 11, provide a copy of the recorded subdivision covenants, indentures, restrictions, Section 410.060C, if any. It's a major issue that's a stumbling block that we've discussed extensively here. Number 13, I would add a 13 issue that he needs to go through the approval process through our county superintendent, county engineer for road and highways for a permit for an entrance exit plan. I don't know if you've all been out to Hopewell Road, but you just turned down a business opportunity here on Hopewell Road. Hopewell Road has a lot of safety challenges on it. It's a hilly road. It's unimproved. It has a lot of safety lacking requirements. It causes a lot of traffic accidents and a lot of challenges for our county and needs to be improved before we start putting more homes in this area. So I ask you that needs to be a mandate. And where are the necessary land agreements with signatures? I hear the homeowner keep talking about emails and things that have been delivered, but I want to see concrete documents to keep our county out of the circuit court and to keep landowners from having to sue to uphold their rights. I want to see actual documents with signed, legitimate notary public documents that were filed with the county recorder of deeds. So far, all I've heard of a lot of hearsay, and I'm sorry for your loss. I'm sorry for the hard times you're going through. But, you know, this county has a responsibility, and this Planning and Zoning Commission has an ultimate responsibility to ensure that our Section 410 of the codified codes, that everybody's treated on an even keel field, that all the dots are dotted and all the T's crossed, and that everybody's being treated the same. To deviate and to give special considerations or free passes in this issue where the hardship hasn't been proven, there's many documents lacking, and I think we're just setting our county up for a legal lawsuit. And you do have a member of the county council staff here. I would implore you to ask for her legal advice and to gain that legal advice to keep you out of court. Because I think that the residents of this subdivision, I don't know if they were notified. I don't see anybody here. But it kind of, there's just a lot of unknown questions. And for that reason, I ask that you either table it in lieu of that. If the applicant wants to go through with the process, I ask that you deny it. The simple putting the cart before the horse, there's many missing documents. I don't even know how the county even accepted this application without these 13 requirements that are missing, 12 written and 1 that I added. For those reasons, I ask that you either table this or that you deny this application. Thank you, Mr. Chair.
Janoff, just for your information, they were notified because we did receive a letter, and the Hertz didn't want to attend because of COVID, and 2 of the trustees are on vacation.
Gotcha.
That's why they're not here.
Cool. But thank you very much.
Anyone else wishing to speak as part of this public hearing? Anyone else? Seeing no one, we will close the public hearing. We can ask the applicant to come back, see if there's any more. Does anyone have any other questions for the applicant?
Can I respond to some of his? No? Okay,
No questions? Okay. Thank you, sir.
thank you.
We'll now bring this application, PRE 20-22, back to the commission for consideration.
Yeah, I got a question for Mr. Meyer. He mentioned that the next step would be to come to the county council for a vacancy of the re-subdivision, is that correct?
Yes.
Explain that to me.
Right. There's a procedure to take land out of a subdivision, and so it's no longer platted, it's just unplatted, it's an unplatted parcel. It doesn't happen very often, but maybe once a year, we'll have an application where someone will apply. I'll give you an example. There was a homeowners association who owned common ground. Part of the common ground was on the far side of the creek that they weren't able to access, and a neighbor wanted to purchase that. And so this was probably 2 years ago, that there's a small piece of common ground that was taken out of the subdivision, and then the neighbor next door purchased that from the homeowners association and combined that with their own lot so they can have a larger parcel. And so it doesn't go through the Planning and Zoning Commission, it goes straight to the county council, but it has to meet certain requirements. It has to have a survey, a drawing showing and a legal description, and those are some of the things it needs.
Okay, thank you.
Have you typically approved these types of things without all of the regulations being met that are spelled out in 11, on all of these 11 things? I mean, maybe 1 or 2 missing, but is it typical to approve something like this with all of these missing?
Well, you can, go ahead.
Well, typically when we make plat comments back to applicants, much of the time they're able to either incorporate those changes and get them back to us quickly, or they will often, if they're unable to do so, they'll often ask for the item to be tabled and continued to the next month. So normally one of those 2 things happens. Either a revised plat is submitted to us within, say, a week or something of the meeting, or the applicant will ask that it be tabled until the next month. That's how it typically happens.
Yeah. Ms. Baber, before a final plat can be approved, then all these things have to be addressed.
Okay, thank you.
Robert, if we approve this and then the county council denies the re-subdivision, the withdrawal from the subdivision, what would be the status of, one's not dependent on the other, is it?
Let's see, did he subdivide the parcel, what is it, 3B? I'm getting mixed up here. The one in the back.
3A.
3A? To de-subdivide the parcel 3A, it's got to be created, so that de-subdivision is contingent upon this action. But on the other hand, if that should fail and it should never been de-subdivided, you'll still have these 2 parcels that still exist within the subdivision. They're still both in existence in the subdivision, and the parcel in the back would have an access easement going to it from Hoffman Hills Drive.
Okay. Okay. Any other questions for staff? Hearing none, Chair will entertain a motion to approve application number PRE 20-22.
I would make a recommendation to amend it, as I was stating, with the conditions being met, these 11 technical conditions, along with the approval of the road board for the driveway to have access.
Okay. Would that be approval from the county or the state, Robert? County?
County.
County, okay,
Hopewell
so
Road.
Mr. Clary's motion is to approve this application with the 11 identified conditions set forth by staff, and then a 12th condition, the driveway entrance being approved by the St. Charles County Highway Department. Is that your motion, sir?
Yes, sir, it is.
Okay. Is there a second?
Second.
Mr. Fromm makes a second. Mr. McDonald, how do you vote? Mr. McDonald? Mr. McDonald, how do you vote?
Yes.
Yes. Mr. Hollander?
Yes.
Ms. Bamer, how do you vote?
Yes.
Mr. Clary?
Yes.
Mr. Kuhn?
Yes.
Mr. Fromm?
Yes.
I vote yes, application passes.
Good luck.
Okay. Next on our agenda is application PRE 20-23, preliminary plat for St. Charles County Ambulance District, base house number 22, located at 3807 Towers Road. Owner is Terry and Janet Hackman. Developer is St. Charles County Ambulance District. Engineer surveyor is Civil Engineering Design Consultants. Current zoning is R1A, Single Family Residential District. Proposed zoning is R1E, Single Family Residential District. Proposed lots are 2. Parcel size is 1.82 acres. The location is on the southwest corner of Towers Road and Cox Hill Road. It is located in Council District 7. Staff.
The essence of this application is dividing one unplatted parcel into 2. And that's really the gist of it. It's at the corner of two existing streets. There's utilities that are available nearby. It's very straightforward. There's 2 things you may want to know about. They've applied for a rezoning because the parcel is split zoning. The south half has a different zoning district than the north half. And so that rezoning application is now before the county council. It's been introduced as a bill, and the county council will take action on that bill later on this month. The other thing that you may want to know about is that they're proposing to take driveway access directly onto a county roadway. Normally, that's not allowed in a subdivision, but they're asking for a waiver to allow driveway access directly on a county roadway on the basis that the lot depth isn't really sufficient to have 2 tiers of lots and to create, several blocks deep. In this case, there's not a sufficient lot depth to really allow for that. Besides that, the lots are large enough that taking direct access and having 1 or 2 driveways on each one of these lots is really not providing that much additional traffic over what could otherwise be allowed for that zoning district, the proposed the R1E Single Family Residential Zoning District. These parcels, should they be divided, would each be a little bit under an acre. And just for reference, it's basically an island in a sea of R1E Single Family Residential Zoning District that have been already developed for lots that are 7,000 square feet, 10,000 square feet, et cetera.
Any questions of staff? Hearing none, we'll ask the applicant to come forward. Do you solemnly swear or affirm that you'll tell the truth, the whole truth, and nothing but the truth in these proceedings under the pains and penalties of perjury?
I do.
Please state your name and address for the record.
Allison Gouch, Civil Engineer and Design Consultants, 10820 Sunset Office Drive, Sunset Hills, Missouri.
Go ahead.
We get this live display on.
Yes. There you go.
So we were here last month, and this should be familiar to you. You guys recommended approval of the rezoning so that it would all become R1E, so that we could create the 2 lots that are each slightly under 1 acre. We also went to council. As Robert mentioned, it was at council this Monday. There were no objections or concerns raised by anyone from the public or any council members. So we have kind of a display just to show what's going on here. We are at the corner of Towers and Cox Hill Road. We are doing the subdivision so that the ambulance district can purchase the northern part of the lot. They are looking to build another base house, reduced response times, and that kind of thing. So as part of that deal, they don't want to purchase more land than they need. They're being responsible with the public money, so they really just need a little under an acre. And the current owners wish to retain the southern half of the lot for now. Their home is immediately adjacent to the south. Now with the subdivision, of course, they could change their minds in the future and sell that lot. But for now, they have no plans that I'm aware of. That lot would be retained by the owners of this property here. So a couple things to note. There are utilities available. We are proposing to construct a new sanitary sewer line that would come from over here in the right-of-way and serve both of these lots. As part of the plat, we do have easements for that sanitary line. We also have been looking at site distance with staff, and in looking at that, there's just a little sliver across, I can pull up the site distance. There is a little sliver across the southern lot. So based on the requirements for site distance that you have to show your car being so many feet from the edge of the pavement, there's just a little sliver right here that a car or ambulance leaving the north lot would need to look slightly across that south lot to see the full distance. So we are showing a site distance easement that would prevent them from building, which is kind of academic because it's basically right on top of the sidewalk and only a couple feet from the property line. I don't know that they could build there anyway, but we did include that site distance easement on the revised plat that we sent to staff last week. I think that's kind of the high points, unless anyone has any questions for me.
Any questions for the applicant?
Could that area that is the site distance issue, could that be regraded slightly to?
It's not a vertical issue, it's just a horizontal issue. So the
okay.
requirement for site distance, I have it on here, I think it's 12 feet from the edge of the pavement. You have to show the vehicle being back. And so basically when they look right, they just look right across the front sliver of that adjacent lot. And that's not really uncommon.
Okay, I thought perhaps, you've explained it.
Yeah.
Any other questions? Hearing none, thank you, ma'am. We will now open the public hearing for application PRE 20-23, preliminary plat for St. Charles County Ambulance District Base House Number 22. You solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth in these proceedings or under the pains and penalties of perjury.
I do.
Please state your name and address for the record.
Thank you very much, Mr. Chairman, members of the Planning and Zoning Commission, Arnie A.C. Dinoff, public advocate and resident, mailing address, P.O. Box 1535, O'Fallon 63366. First of all, I'm a proponent of this request, the applicant's request for the preliminary plat, preliminary lot. The ambulance district makes a nice product for their crews. It's a mix of building materials. I just want to go on record with a couple concerns that I have for the final product and the final plan. Number one, after review of the plans, I don't see any runoff. What are we going to do with the runoff? Is there a retention or a detention area planned for both of these parcels once they're split? That runoff to the south and to the west, there's some subdivisions, so we don't want to create unnecessary water runoff. Surface water protections are in place. I did have a question about the septic system, but the applicant had answered that, where they're going to install a sanitary sewer construction. And then the other requirement is I don't see a plan for landscaping or the county tree code requirement. So if the ambulance district, there are trees currently on this property, I don't know if they plan on knocking them down or planting new trees and landscaping. There needs to be a landscaping plan, and I don't see that. I'm sorry?
No trees. No trees on the lot.
Okay.
Yeah.
I don't know what their plan is in terms of landscaping and erecting trees. I guess it was the second lot that maybe had the trees that I saw. But besides that, I'm for this application. Thank you.
Thank you, sir. Anyone else wishing to speak regarding application PRE 20-23? Seeing no one, we will close the public hearing. Ask the applicant to come back. Anyone have any additional questions for the applicant? Ms. Bamer, Mr. McDonald, you have any questions?
No.
Hearing none?
No.
I guess I do. What about the runoff from the lot? How's that going to?
Yeah, we are meeting the county requirements. We have been discussing that with county staff, and all the calculations will be included when we submit our improvement plans for their review. I know water quality is a thing that the county is starting to work into the code. So staff has suggested us trying to make some efforts to allow some of the downspouts and some of the water from the parking lot to sheet flow if possible across some grass to give some opportunities for infiltration. Because the topography, we weren't able to sheet flow the parking lot because the stalls are actually on the highest end of the lot. But we are trying to work in some grass swales and also intend to do what we can to daylight a couple of the downspouts and let them go across the grass to give a little bit of an opportunity to slow down the water and absorb some of it. That being said, it's more of the county has asked that we try to do this, and we will meet the code and hopefully go a little further.
Okay, thank you.
Any other questions? Hearing none, thank you, ma'am. We'll now bring this back to the commission for consideration. Anyone have any questions, staff, comments? Hearing none, Chair will entertain a motion to approve application number PRE 20-23.
Motion.
Motion by Mr. Hollander, is there a second?
Second.
Second by Mr. Clary. Ms. Bamer, how do you vote?
Yes.
Mr. Clary?
Yes.
Mr. Kuhn?
Yes.
Mr. Fromm?
Yes.
Mr. McDonald, how do you vote?
Yes.
Mr. Hollander?
Yes.
And I vote yes, application passes. Okay. We have no continued items on the agenda. The next item on the agenda is the approval of the minutes for the August 19th, 2020 meeting. Is there a motion to approve those minutes?
Motion.
Is there a second?
Second.
All in favor, sign aye.
Aye.
Other business. Robert is going to give a presentation regarding the proposed post-construction stormwater management regulations.
This is exciting.
I'd like to
I'm looking forward to it.
introduce Rich Necko,
It'd be nice if we could have some
who's the Development Review Division Director for St. Charles County. And although you don't see Rich much, Rich and his division in planning and zoning will work very, very closely on all plats, for instance, and stormwater and all sorts of issues, erosion control. And Rich can explain that in much better detail than I can.
Welcome.
You've heard it come up a bunch tonight already, so I appreciate you giving me this opportunity. We're trying to, I'm going to bring you up to date on some stormwater quality regulations, which is a part of why we're doing this, but we also recognize that we've got some issues with our stormwater management requirements. We're probably not up to speed with most of the municipalities around here. So with that, again, I appreciate the opportunity. And we'll talk a little bit about stormwater. I'll try and keep it as quickly as possible for you. I know we had some long hearings tonight. If you have any questions, please feel free to stop me at any time. I'd be happy to answer any of your questions. Just give you a little regulatory of history of how we got to where we are with stormwater management. There were a lot of Rivers and Harbors Acts in the late 1800s, early 1900s. Basically, the federal government was using these to dredge our harbors, make sure our navigable waterways were safe to travel in. They're dredging them, keeping the channels cleared. And the big part that I wanted to get about this is that the federal government was challenged on several occasions during the 1800s and 1900s about whether they have the jurisdiction to spend tax money to do this, to clean up our nation's waterways and harbors, and the Supreme Court continually ruled on the federal government side that they had the jurisdiction to manage our waterways, mostly under the guise of interstate commerce. It was actually the River and Harbor Act of 1899 that gave you your first environmental law in the United States of America, and it was written that you cannot discharge into a navigable waterway of the United States without a permit. So that was our real first environmental law. The next big regulation as far as stormwater is concerned was the Federal Water Pollution Control Act of 1948, and there were many amendments to it. I think we realized the need back then. We were discharging sewage directly into our rivers. We were discharging chemicals. The industry was, that didn't really catch up till 1972. But we started looking at these point discharges that we were discharging into the river and became concerned about those and how we were managing that and polluting our waterways. But in 72, the big one came, and that was the Clean Water Act, which was actually just an amendment to that Water Pollution Control Act. And that, you may remember in 1972, the Cuyahoga River catching on fire. Actually, that was in 70. We had a lot of problems with the Great Lakes. Lake Erie had a lot of, it turned green every year. It still does, large portions of it, because of the nutrients are in it. But that got national recognition, and it spurred Congress to create the Clean Water Act. The Water Quality Act of 1987, basically their approach to trying to address cleaning up our waters, they created this National Pollutant Discharge Elimination System. There's a lot of acronyms in this stuff too, so if you have any questions, please ask. But they created this system, National Pollutant Discharge Elimination System. In 87, they revised that to take a two-phased approach to stormwater pollution and regulation. There were many other amendments of the Clean Water Act. I won't go through them tonight. I got another 45-minute PowerPoint presentation on the Clean Water Act. But the two-phased approach that I'm talking about started with the phase one dischargers, and this started in 1992. And essentially, they're starting to go after the industrial dischargers, the stormwater treatment plants, the large, what we call MS4s, which are municipal separate storm sewer systems. So a lot of communities have combined sewer systems. The city of St. Louis has that, where you are putting your stormwater into the same system that you're putting your sanitary sewage in. And it all goes to a treatment plant and get cleaned up. Except when you have too much water in it, and then it discharges, and we have a problem with the discharge of that. The county doesn't have that problem, but most of the larger communities and older communities do. So those were all regulated as point dischargers and under phase one. The point source is clear. It's coming out of the end of a pipe or someone's pipe in industry or at the water plant, or it comes out in the form of sludge that they're trying to get rid of. And those actually have qualitative or quantitative requirements. You can only put out so much effluent. There's certain requirements in the sewage treatment plants as to how much phosphorus you can release, how much fecal coliform and E. coli and whatnot. So they have quantitative sampling requirements. The phase two dischargers is what we're going to fall under, the county is, and what we do fall under. And mostly those are the small MS4s and small construction sites, less than 5 acres, but over an acre. So the county is a phase two non-point source discharger. And when they refer to non-point source, they're talking about water that's falling on your rooftop and on your driveway and in your front lawn. And maybe you fertilized your lawn too much, and now we're washing chemicals off of that. But that all washes into the street, that washes into our storm sewer. That does not go to a storm sewer or a wastewater treatment plant. That gets discharged directly into our rivers. So that's the need to identify that pollutant source. In fact, studies have shown that's definitely the majority of our water pollution in our nation's waterways is from a non-point source pollution, maybe up to 60% or more. So kind of the way this is handed down to us is that the United States EPA is the federal agency that's managing the Clean Water Act. They have delegated some of their responsibilities, and they tried to do all of the stormwater permitting to the states. Not all of the states have a program, but most of them do now. They've come a long way since the 80s. The other thing that you will see is that they've delegated some of their authority to the Army Corps of Engineers. So when you're doing construction or doing any kind of construction that would involve a jurisdictional water course in the United States or a wetland, the Corps of Engineers gets involved and has to issue a permit for that disturbance, or at least evaluate it. And then we're at the bottom of all that, so all of these regulations get filtered down to us. We're not given any federal money for this. We're not given any state money for this. But we have to spend money on this, and we have to address the permit conditions. So as I said, we are a regulated small MS4 under this NPDES program. The permit authority that we adhere to is the state, Missouri Department of Natural Resources. They have a stormwater permit that we have to follow, and we have to create a stormwater management plan for. And they also have to, all of their permit conditions have to be approved by the US EPA. So for these phase 2 dischargers, we're a little different. We're not going to have these quantitative sampling requirements. We don't have discharge requirements. We don't say that you can put so much of this out of a storm sewer pipe. We don't have those kind of requirements. What the Clean Water Act says about non-point dischargers is you need to have a stormwater management plan and program put in place, and you have to be running it the way you say you're running it. And it has to address these 6 minimum control measures to the maximum extent practicable. So we don't have any kind of quantitative standards. We have maximum extent practicable. And the state of Missouri, Missouri Department of Natural Resources, is deciding that maximum extent practicable. So we have to address these 6 minimum control measures in our stormwater plan, and they have more requirements than just these vague general categories. But these are the 6. Public education and outreach, which is kind of what we're doing tonight. But we do have a whole program where we go teach younger children. We go do outreach to adults. We've got stream teams, things like that. So we do try to, and all of these work together too, because when we do have problems with illicit discharge, which is number 3, the first thing we try to do is provide education on why, this is what we found, this is why you shouldn't be doing this, this is what this affects, rather than go straight to enforcement on stuff like this. Number 2 is public involvement and participation. This, again, is some of it, but more than anything, we want to try and get the public involved in our stormwater management plan and the regulations that we're adopting. Illicit discharge detection and elimination. If someone's dumping oil into a storm sewer, we need to have a system to be able to identify that, or should we get a complaint to identify that? We have to have a system to go look and try and find out where the source of that came from. And it's just not residential use, but that's predominantly what we have in the county. We do have some industrial and commercial where we'd have to do this similar things. But we have to have a program to address that and enforce that. Construction site stormwater runoff control, developers going out and building streets, subdividing property, what you guys are involved with here. While that's all under construction, they have to protect that property, and we have rules and we have regulations for inspection and enforcement actions for all of that. The 5th one is what we'll be talking about for the rest of this evening, and that's post-construction stormwater management and new development and redevelopment. And that's probably where we're a little bit lacking, or at least that's what the state says. And so that's why we're here tonight. And the 6th one is pollution prevention, good housekeeping for municipal operations. So the county highway department has several facilities where they have trucks and salt piles and things like that. Our county facilities has several facilities like that. Our sheriff's department works on vehicles. So all of these they also have to follow the rules, and we can't be just dumping our oil everywhere, and we need to make sure these sites are clean and they're not discharging pollutants into our stormwater. So basically, getting into the nuts and bolts of MCM number 5, these are some of our concerns and our solutions for it, but essentially over 95% of our storm events go undetained with stormwater detention, which were a lot of the questions tonight, and untreated, and are discharged directly into our ponds, streams, and rivers, causing pollution, erosion, and flooding to our natural systems and to private property. And we were audited in 2018 by MDNR for our stormwater management program. We did pretty well in that audit, but they did find our post-construction stormwater management program, namely our structural BMPs for trying to clean up our stormwater and reducing the volume of our stormwater, were not being addressed to the maximum extent practicable, which is what they felt. So what we are now trying to do is create new ordinances, revise our ordinances, create new design criteria that's going to address this water quality in addition to the stormwater runoff rate that we already have standards for. Our cities we're a little behind in this area. Our cities have already adopted ordinances like this. St. Charles County, St. Louis City, MSD basically is covering a lot of the St. Louis area, have adopted similar ordinances to this. But basically they're looking at a nested approach where they're looking at treating water quality volume, channel protection volume, and the flood peak protection, which is what the county currently does, but not the ones in red. These are some of basically the other cities have adopted standards from other agencies. The county basically has done the same, only we're putting it in our own words and form. But most of our stuff is coming from the Georgia Stormwater Manual. We also use some of the manual stormwater manual and some of the other municipalities from the area. Our outreach on this and trying to create these ordinances and trying to create this new design criteria and these new regulations, we wanted to work with the development community. We wanted to work with the Soil and Water Conservation Commission. We wanted to work with all kinds of different stakeholders in the county. The agricultural community is a big part of this county. They've made several complaints about some of the drainage issues that's going on in the southeastern part of the county. We had county council members on the stakeholder group. We had a city council member on the stakeholder group. So we tried to get as many people represented that would be involved in these regulations as much as possible to try and come up with a draft that everyone could live with. And it was a diverse group. We also had members or people that do the inspections on the maintenance of these facilities. So we had design people, we had construction people, we had people that looked at the long-term maintenance of these to try and help us draft the best regulations that we could. And from this, the group established these goals. We wanted to encourage and incentivize the use of non-structural BMPs as much as possible to reduce the need for these structural ones. So the non-structural best management practice are things that I think the county has done a very good job on over the years. We do preserve buffers around streams. We preserve tree canopy in residential subdivisions. Basically, the non-structural BMPs are things that they're either going to plant or create, or they're going to leave the natural area natural and conserve it. So those go a long way into intercepting stormwater, treating stormwater, and we've offered a lot of credits. And rather than create more regulation and more buffer requirements, we've incentivized the developer to increase that buffer area. So we require 25 feet around most of our buffers. If you want to go to 30, you're going to get a credit for that, and that's going to reduce your need for the structural BMPs. It will reduce the volume of treatment you have to have. We wanted to be flexible in our design, so we have allowed, while we do have our standards, and we have standards that they'll have to meet, we do allow BMPs from other municipalities, other agencies that have been approved by DNR or US EPA. So we're trying to allow multiple agency or use of multiple designs to achieve this as much as possible. We want to allow and encourage BMPs that address multiple water quality benefits. So we don't need to have one of these facilities, one of these facilities, one of these facilities, if they can all be put into one and achieve the same thing for a less amount of money. These need to be economical to construct, and they need to be economical and easy to maintain for the people that are left to maintain them. And that's going to be the subdivision homeowners, and that's going to be the commercial site plan owners. The structural BMPs need to be an amenity to the development, not a nuisance. So we shouldn't have a concrete box and run stormwater into it, but we would expect something is to be mimicking the natural condition. Hopefully that's going to help you sell lots and not be a hindrance to your lots and not be a mosquito trap. And the bottom line too is they need to meet MDNR and US EPA regulatory expectations. So these are the things that we are doing now. On the left side, as I said, I think the county's done a really good job of doing the non-structural BMPs throughout the year. I think we've avoided a lot of the need for the structural things, but we still have problems, and staff recognizes that. What we have done is to try to beef up some of these non-structural BMPs. I'm sorry, the green didn't come out very well in this. But we're still leaving all these ones on the left and the same. If you want to do more, you're going to get a credit for that as far as buffer protection and tree and open space preservation. So that will reduce your structural BMP requirement in the end. The same thing, disconnecting rooftops and impervious surfaces, which is what the engineer was talking about today with the fire station. And they're going to try and address water quality that way by trying to get it to run a long way over a flat slope of vegetated area and try to slow it down and get some of that soaked back into the ground. Open channel design can be done the same way if it's spread out and we have small depths of flow and small slopes. And then if they use environmentally sensitive design where they are trying to do a lot of open space and tree preservation, clustering lots, things like that, there'll be credits for that as well. So all of these things on the right now will help you reduce your structural BMP requirements. What we are changing though is that basically we only have the boxes circled in green and yellow are what we're providing today. So we're providing stormwater management for these really large storm events. We start at the 2-year 24-hour event and the 10-year 24-hour event. The 2-year event equates to about 3.5 inches of rainfall over 24 hours. And the 10-year one, we're getting up to about 4.8 or so. So we're handling large storms. We don't see these storms a lot. And the stuff that you see at the bottom, the channel protection, the water quality storms, those are smaller events that are probably running through our detention facilities now without being treated at all. We're probably not even detaining that because the amount of rainfall is so small. So I think that's a good graphic to show you what we are doing and what we're proposing to do. And so just number-wise, I'm an engineer. I realize probably most of you aren't, and I've got pictures of these, but these are the differences. Currently, we're only looking at that 2-year and 10-year event. For some of these smaller storm events, smaller sites, we do let them look at the 20-year event, and we have different rain events for that. But what we are going to propose now is that you do have to provide water quality treatment for the first 1.14 inches of rainfall. And the 1.14 inches of rainfall is an odd number, but essentially that covers 90% of all the stormwater events that fall in our area on an annual basis. So 90% of all of our rainfall events are either 1.14 inches or less. When we get a 3-inch one, that's still going to treat the first 1.14 inches, which is significant because when you go out and look at a rainfall and we get the slow rain and then it starts speeding up and whatnot, all the stuff that's washing off the street, the chemicals that are washing off the yards, that's coming off first, and that's going to be treated before we get those larger flows into these basins, which will end up bypassing those systems. The second thing that we're wanting to add to into the stormwater management is channel protection, and so we're proposing an extended detention of the 1-year storm event, and that's a 2.8-inch rainfall over 24 hours, so it's a little bit bigger. But those are the kind of events that eventually form our channels. Those are events we get once or twice a year. They have enough velocity. Those are the channel forming events. Those are the events that are about to get over the overbank and start flooding our streams. So those are the events that we want to protect our streams with. We see a lot of complaints and property damage from our open channels when we get too much runoff. And that's common, urban erosion of a channel. And then we will keep our overbank flood protection. However, we're going to get rid of the 2-year event since we now have that 1-year 24-hour storm. And that water and that extended detention gets put out a very small opening. It gets put out into the channel over a 24-hour period or a 48-hour period. So you're slowly releasing that water back into the stream. We're reducing that velocity and we're reducing that rate of runoff. So we didn't see the need to keep the 2-year event when we already had that. It seemed overlap, and studies show that that's overlap. So we will keep the 10-year 24-hour storm event for the overflow or our flood protection. nothing changes there. So this is kind of what you would see now if you looked in a county subdivision development. The one on the left's a dry detention basin. We had concrete swales in them. We're not doing that anymore either. We want to try and soak this water into the ground. So we're not allowing concrete swales anymore. We have been installing for the last 2 or 3 years, putting amended soils in the ground, putting under drains in there, also putting in native vegetation in some of these, but most of them are turf grass. But that at least is going to allow that water to soak back into the ground. It'll treat some of those smaller storm events. But at the end of the storm, when you got to go back in and mow the turf grass again, hopefully it's not going to stay wet at the bottom and you'll get good drainage in that. The one on the right is something you'd be seeing similar in the county also if you had a wet detention basin. But essentially you can see those outflow structures. The one on the left, there's a small opening on the bottom. At the top, you probably can't see it, but there's a larger opening for that 10-year. So that smaller one's taking that 2-year event. The upper one's taking that 10-year event. And once you get into the top and start overflowing, that's taking those events that are larger than that. And that whole basin will take a 100-year storm event. So we do require that. We don't require the detention of the 100-year storm event, but the basin has to be able to pass it safely back into the natural waterway. You see something similar on the wet one with that small opening on the bottom. What you'll see now, and hopefully you'll see these all in one system, but if you see them by themselves, this is what you would expect to see for water quality. And probably 2 ways that we're going to try and control volume in this county is we're either going to try and soak water into the ground, and as probably all of you know, we've got clay soils once you get down 12, 16 inches. Got mostly clay, so it's going to be hard to get rid of that water. We can provide amended soils in these, which we have. We can provide under drain systems, but these things will probably provide more filtration than they will volume control. You're not going to get deep recharge into our water table. Once it hits that clay layer, you'll get some infiltration, but it's probably going to stop at that point. So these are typical. These are newly planted. Hopefully they'll look better than that as they move on. But you can see the structure in the center on the right is sitting higher than the rest of the basin. So that's designed to carry that volume of storm water in and infiltrate it in through there and filter that water out. And then when it gets so high, it's going to go out that pipe that you see in the background and underneath that road. So when you get an event that exceeds that water quality volume event, we're going to pass that storm water on. Something similar, same thing in the left, although you can't see the structure at the end. It's a honeycomb structure, but similar type of output. What I like on the one on the left too is that there's a RV storage lot over on the right, and all the water from this, all the drainage from this lot, and all the petroleum and all the other stuff that comes with the storage of these vehicles ends up draining into this, so it's being treated in that before it's being released. But you can see a nice grass filter between that nice white vinyl fence and this facility, so that's helping keeping that facility from being eroding. The big thing about these things is if we start getting clay sediments in them, they clog up and then they got to be redone because they won't pass water through them anymore. So that's a really good design there. Another one I thought was interesting is this is World Outdoor Emporium off Highway 94. They put in a sand filter and they did it so that they could display some of their products there. So they've got all these little rocks that are basically not real rocks and are ornamental, but they got them set up on their sand filter. What they did was build some additional parking. You can see that on the left-hand picture. On the bottom right-hand corner is the additional parking and the new asphalt curb. And all the area from that new additional parking runs down that curb, and then it spreads out and drains into that sand filter, and it goes down into the sand filter and it's treated. You can see the outlet pipe right there. So it's going through the filter, being treated, it comes out cleaner and comes out through that outlet pipe. And they were able to incorporate that into their facility and help market their products while they're doing this, which we love. We love that kind of stuff. And one picture I don't have here that you'll probably see a lot of is underground stuff, especially for commercial lots where the price of the ground is very expensive and they don't want to waste any bit of that ground. So you'll probably see some of this stuff that's being designed underground. For channel protection, and I apologize that these slides aren't bigger, but this is that extended detention. These are some of the different structures you'll see, but this is probably the one that's preferred because the normal pool of water is going to be up here. That's where it's got to come out of the structure. So that small little pipe that's letting that water out really slowly that we talked about for that 1-year storm event over a 24, 48-hour period, that's protected from getting a bunch of debris on it and stuff. And these are going to be smaller openings. So this is, we like this design the best, but we're gonna allow flexibility. We're gonna allow a lot of different options. Some of these have hoods over them, like this one does right here, although you can't see it very well from the drawing. Some are protected that way. We'll also use different weir shapes that allow V-shaped weirs. As they go up, are gonna allow more water to go out, but not much at the very bottom. So there's different ways that you can achieve that, but these will be new to the county. And then hopefully this is what we'll be getting to for the most part, where you can provide all of these things in one shot. Here you got one where I would call this is offline. This is going to provide your water quality and your extended detention. The flow of that water is coming from the storm sewer, and the low flows are diverted into here, where they're going to be cleaned up in a forebay. They're going to go into this area that's with the modified soils and the under drains. It's going to filter, it's going to get cleaned up, and it's going to get discharged back into this basin and come on out. When we start getting those larger storm events, that gets bypassed from this basin and gets directed directly into here. And that outflow structure is designed to meter the flow out based on our requirements for extended channel protection and overflow protection. This one's all in one, and it's kind of stacked on top of each other. So you're getting that water quality volume down below, and it's going to be planted. And then you're going to get that extended detention up above with another opening in this structure. And then above that, you're going to get those larger storm events being passed through there. So that's kind of the goal that we're hoping for, to see it all in one shot. So like I said, what you're seeing now is in the old case for these detention basins is on the left. Hopefully one you'll see is going to be more, that's going to be more recent, will look like one on the right, where we've got the water quality stacked up around the edges because we got a bench around there. We're in Missouri, in this area, we're probably going to do better trying to evaporate the water, trying to let it soak up through the plants and let them transpire the water than we are trying to soak it into that clay soil. So I think these facilities are going to be more beneficial to us, ones that can hold the water and evaporate it more so than the ones that are trying to infiltrate it. I think we'll just get more filtration that way, which is fine. We're cleaning the water, but we're not actually getting rid of the volume of water.
Now, will the new facility take more space, more square feet?
I don't think it would. I don't think it would. You kind of have this now on this one here, but you're gonna use that bench area for water quality, which it's not designed for now. So I think you could probably do that. I'm not saying it won't be the exact footprint, but I don't think it would be much larger. But certainly if you're gonna try and do these in 3 different facilities, yes, that footprint's gonna
Yeah,
be much larger.
The old and the new, we might have to give up some of our tree preservation to get the.
Well, again, the way we've tried to write the ordinance and the way we tried to write the design criteria is the emphasis at the initial part of the design of the development is to look at these non-structural BMPs, look at these conservation things you already have on your site, try to preserve as much as you can. And this is gonna reduce your need for this type of thing, and that's gonna reduce your footprint for that type of thing.
On your new one there, would that require some kind of, on this area, we're gonna let the plants more or less absorb it. Do you have to do some substructure or subgrade things like put sand into the base, base, or what are you doing to, I guess, allow that absorption to occur?
You're gonna get more evaporation and you're gonna get the water to take up, the plants to take up some of the water.
But you're not doing anything subsurface to amend that?
No,
Okay.
City of St. Peters has put like some zinc something in there to try and try and attach to like phosphorus and other nutrients, but we don't have any plans for that at this point in time. And you do see that this does have a little problem with nutrients, although a lot of that's duckweed, it's not just algae. But you can expect that since all the backyards of this dump into here. And actually, this is where one of the storm sewer pipes dumps out. And we've got that's so well established in plants, there's no erosion, there's no problem here at all. What I would say is that you got a lot of, what do you call them? The reed canary grass, the cattails, those aren't, I wouldn't say those are the highest and best aquatic plant that you'd want to have around there. I think they could do a better job with plant selection. And then again, maintenance is going to be required on all these, and we'll get into that in a little bit too. So when you start getting these invasives in there, they got to be removed or they're going to take these aquatic plants over. And they are, and some of these, they are essential to getting rid of that water quality volume or filtering the stormwater. But yes, there is a potential for putting additives in that bench material to try and attract with pollutants and nutrients.
Yeah.
So these are the proposed revisions that we're going to be bringing forth. We have in section 405 in site plans, this will be required for commercial site plans. Essentially, the water quality is going to start being required when you get to 1 acre of land disturbance on a new development or redevelopment. The extended stormwater detention, that 1-year detention is going to be required when you get into a certain stormwater differential, and they'll have to do a study to show that. But basically, you're going to start getting enough impervious surface that you're creating enough stormwater runoff differential in your new development that will be required. We are also amending the ESC performance guarantee section to include that for the stormwater quality BMPs, so we don't have to create another instrument to do this with, and we can release them all out of the sediment and erosion control stormwater performance guarantee. And there will now be we require these anyway as built, but we did never have it in the ordinance, so now it's officially in the ordinance. And again, there needs to be an agreement for long-term preservation and maintenance of these BMPs. We have this document, we've been putting these in for years, even though we don't have regulations for them. We've been trading some of the smaller stuff off for stormwater detention on smaller sites, and people have been volunteering to put them in, as we've been asking for it too. So we have created a document, and we do require the recording of the document. We require the engineer to provide a maintenance plan for whatever they're providing, is that structural BMP or the non-structural BMP. There's a schedule for maintenance they have to follow. There's a easement on there that's preserving the stormwater management facility in its perpetuity, and it also gives the county the right to go in there and inspect it and to make sure that it's being preserved and maintained. And we do have a section in the ordinance that requires this too, and I'll get to that in a little bit. Section 410 is our subdivision development ordinance section. Again, this will now be required for subdivision development. One of the things we did do while we were here was correct the tree preservation ordinance. And one of the things we were getting into tonight was if they can't meet the ordinance, what do they have to do to meet it at that point? And basically, you need to plant more trees. Well, the section in there was referencing the wrong section, so we basically just tried to correct that. And we were more descriptive in how we did that. And again, whoops, keep looking for that laser pointer. And again, while we are requiring as-built plans to release the subdivision improvement performance guarantee, it was never in the ordinance. We are now officially putting it in the ordinance. And again, we had to go back and correct section 412, which was erosion sediment control, so that we could allow these facilities to be put in that performance guarantee. And that's the only change that was made out of that one.
Excuse me. On these subdivision developments, before we see a preliminary plat, do you all have this reviewed?
Yes.
So you've already done that before it comes to us for a preliminary
It
plat?
depends on what you're talking about, yes, but yes, we do review all of that and conceptually. As far as tree preservation, that starts out with planning and zoning, and they make sure that meets the requirements. when the subdivision improvement plans come to my division for review, and now we've gone from conceptual to detailed improvement plans, we make sure that that continues on. When that goes to record plat, and when it goes to starting to develop on building lots, it goes back to planning and zoning, and they make sure that the tree preservation ordinance is still being upheld. So yes, we do this throughout.
So we don't have to ask these questions.
Well, you shouldn't have to. But
Shouldn't have to.
So on a subdivision, let's say, I mean, I can see where this is really geared to high-density type of developments, and that would make sense. But on, let's say, one where we get something that's 100 acres, and they want to subdivide it into, let's say, 33-acre tracts, what are the controls that are in the system to address the runoffs, the impervious surfaces, the roofs, driveways, patios, street surfaces? What is in the ordinances or code right now that addresses that?
right now, there's nothing. If you're splitting it into a minimum 3-acre lot development, there is no stormwater detention requirement. Unless there's known stormwater problems downstream, then that could be provided or required. But right now, there's, for 3-acre minimum lot sizes, there's nothing. You have to be less than that to start requiring stormwater detention.
Gotcha.
Okay, so when we get, over the years, we've had numerous, the two brothers and the sister wanted to subdivide the family 15 acres, the farm. Then they're gonna have to now,
Depends on how they do it. And again, this hasn't gone through council, nothing's been approved yet, we're just proposing this, but what we're proposing in the new ordinance, as far as 3 to 5 acre lots, are that you would have to provide water quality. The HBA hasn't seemed to had a problem with that if you get to that 1 acre of land disturbance. But we are also proposing that you have to provide that stormwater detention if you have a runoff differential from a 15-year storm event of 5 CFS. So the HBA's had a little bit more problem with that. We're discussing the reasons why. With that, we've also offered a whole lot, for those larger lot developments, we've offered a whole lot more credits for them, to the point that if they did that, they probably wouldn't need the stormwater detention anymore, if they did that, or even if they just preserved the natural conservation features that are already on the site. So a lot of those are in agricultural development, right, that we're getting for those. And a lot of those have natural water. I mean, they have, they'll have grassed waterways, they'll have ponds, they'll have buffers along their water courses, they'll contour and put terraces in on their farms. So they have they have soil conservation features that are being removed by the development. And, sometimes they may generate more runoff, sometimes they may not.
Yeah, that's my concern right there, is that there really aren't any controls once it gets
And if
redeveloped.
you've got a property in agricultural development that's got a lot of good soil conservation features on it and they're removed, my guess is that you're probably generating more runoff now.
Would there be any way of codifying the amount of impervious square footage or whatever that's created that would require a developer to then place that in their development plan?
We had that in there, and we had like a half acre of impervious surface for
Yeah.
the need for extended stormwater detention
Right.
and peak. The HBA had a problem with that and didn't see that need since we already had the 1 acre land disturbance threshold. And when we went back and looked at a lot of our projects, we agreed with them. There was only a couple of them that would have slid into that spot. So I think we're getting most of these. I don't see a need to do something to that. Try and finish up quickly for you, but we are creating a whole new section in the design criteria for stormwater management, section 70. Section 50 that was in there now covered the stormwater management and the conveyance of stormwater. So our stormwater pipes have to be so big and this is how they got to be designed, and our inlets have to be so big and this is how they got to be designed. So we kind of split those apart now and put the stormwater management into section 70. So we've got a section that tells you when all of this is required, and I've gone over that with you here a little bit. We've got the design standards that you have to meet for these 3 stormwater management conditions. We have keep doing it. We have requirements for BMP preservation and maintenance. So like we said on the commercial site plans, they're gonna have to have a deed restriction that gets recorded on the property with the maintenance schedule and whatnot. In subdivision developments, that'll be part of the subdivision trust indentures. So it'll become part of that. We have, like I said, our strategy at the front of the book was to stress these non-structural BMPs as much as possible, and then we don't have to have these structural ones, or as much of them. Again, someone's got to build all these, or someone's got to build these structural ones, and someone's got to maintain them. So we'd like to reduce the amount of these as much as possible, and then we have to inspect them. The last part of the design criteria will be technical design guidelines. And again, we're going to have our own that are in there, but as I said earlier, we're going to be flexible. We're going to allow the use of other agencies' design guidelines, as long as they meet our design standards that we've set at the front of that book. As I mentioned, we already have a section in the ordinance, section 420.020, and that addresses the long-term preservation and maintenance of our detention basins and these new stormwater management facilities. So we had a little foresight, and we got that in there before these new requirements. So we do have a method for requiring maintenance to these and enforcing maintenance of these. And we are not proposing any changes to that section. And this is kind of where we are now. So we had stakeholder technical peer reviews of our preliminary and final, well, we haven't had the final draft yet, but the preliminary draft. We just had the 30-day public comment period for our final draft. We had advertised that on our website and all of our communications and the county newsletters. Didn't get a big response to that, but we did advertise it. We'll do a better job when we start working on our stormwater management plan for our next permit, which is next year. But that was a link to the site. September 14th was the end of the public comment period. We are still taking public comments, and we will until we get this drafted. We are doing reviews and presentations. We did one to the Floodplain Vision Board last week. We've submitted things to the Commission on Environmental Quality. We're doing this presentation with you. We plan on doing a workshop session with the County Council in October. And then the next step would be adoption of the ordinance by the County Council, and then we would publish the new design criteria. And then we plan on having technical workshops for the development community and our staff so that they understand these new regulations and how we're going to manage them and how we're going to regulate them and implement them. And that's a nice little rain garden we have at Emmanuel Lutheran School that the kids actually did. So we tried to get the educational component involved in those too.
So we're looking at another 90 to 120 days before this is all wrapped up?
I'm hoping that this will get through council in November, and probably we won't have the design criteria published until then or December, is our hope.
These water detention areas are going to silt in over a period of time. Is there any requirements that require these dredged from time to time? Or how are you going to address that? Because that's going to create a problem, obviously, too.
A lot of this will be, what will be required on a lot of these is you'll have to have a forebay for when you have significant amount of flow coming into these. So hopefully that forebay is going to filter out a lot of that stuff, and especially the bigger stuff.
Oh, okay.
And that will be easier to clean out than the whole thing.
Right.
But you're right, over time, that's gonna happen, and that's gonna be part of the maintenance. My bigger worry is these water quality facilities, and if you start getting clay in those, they're ruined, and that's gonna be a big expense. And if you ruin them, I mean, if it's a small thing and you can dip a blade in there or whatever and get the first inch out, you're fine. But if it's something more significant than that, I mean, it could cost you as much to repair one of those as it would to put it in, if not more. Because you can't compact that soil in there. That's the whole point of it. It's a different animal than anything we've done before.
So move out of those subdivisions before you had to pay for it. Exactly.
Thank you very much for your time. I appreciate
You
it.
got work
Thank
to
you.
do.
Thanks.
That's
So
great.
you got work to do.
Eventually.
Any other division updates, Robert? Okay. Motion to adjourn.
So moved.
All in favor, sign aye.
Aye.
Aye.